Members of the jury, in this action it appears that the plaintiff and the defendant, sometime towards the end of January of this year, entered into a contract for the sale of 12,000 bags of coffee by the defendant to the plaintiff. The coffee was delivered, accepted, and paid for. Out of that transaction there arose a dispute as to the quality of the coffee. With that dispute we have no concern here at all. It makes no difference in the decision of this case who was right or who was wrong in the controversy that arose between these parties. It makes no difference whether the coffee was of a good grade or a bad grade, whether the tests that were made were properly made or improperly made, because it appears that on the 24th day of February, these two people came together and made an agreement of settlement. Whether that was a wise agreement from the standpoint of the plaintiff or the standpoint of the defendant does not concern us at all. They made their agreement, and its desirability or its wisdom is not a subject of inquiry by either you or by the court. That agreement provided that the claims in regard to the quality of the coffee delivered under a contract were to be settled by the defendant paying to the plaintiff $18,000 and the delivery of 4,000 bags at a specified price. The plaintiff comes here seeking to enforce that agreement, or rather to collect damages for its non-performance. The defendant resists that claim upon the ground that the agreement of settlement, the agreement at suit, was induced by fraud, and that is the question that is presented. As you can see, that question is entirely distinct from any question that may have arisen upon their original transaction in regard to the sale of coffee. In deciding this case, you will address yourselves solely to the proposition of whether the settlement agreement was induced by fraud, and not as to what the merits of the controversy may have been in regard to the claim that the coffee was not of the proper grade. The claims of the parties in regard to the agreement of February 24th are divergent. By that I mean that one party claims one thing happened and the other party claims something else happened. In order to establish that he was defrauded, the defendant must show you first that there was representation made to him that he relied upon. He claims that the plaintiff told him before he made the agreement in question two things: that the coffee in fact was inferior in grade, and that a portion of the coffee was what is called straw, of a kind that was different from the kind of coffee that was sold, different in character, not in quality, but of an altogether different kind that could not possibly be accepted in performance of the contract. That is one representation that he claims was made to him. The second representation that he claims was made was that the plaintiff claimed he had documents which would prove those statements. As to those representations, the plaintiff says that neither was made at all. He denies that the coffee delivered was straw, or that he made any statement as to the kind of coffee it was. As to the documents, he admits that he had, and nobody disputes that he did have, the certificates which you have seen introduced in evidence. If the plaintiff is correct as to what he says, then there is no fraud and the agreement is valid. If the defendant is correct as to what the transaction was, he must, in order to establish fraud, prove these things in addition. He must prove that in making the agreement he believed and relied upon those statements, that he took them to be true, and that he made the agreement because he believed they were true, and having that belief, he signed the agreement. If he has proved that the statements were made and that they were untrue, then he was defrauded into making the agreement, and he could not be held to it. There is one other question in this case. If a man has been defrauded into making an agreement, he may, if he chooses, let the agreement stand. If he knows of the fraud and decides to go ahead with the agreement, then he waives the fraud and is bound by the agreement. Those are the questions that you have to decide in this case. If you decide that the agreement was not induced by fraud, that is, that the defendant was not induced to enter into the agreement because of any fraudulent representations made to him, then your verdict would be for the plaintiff.